The Deputy Leader.
Thanks very much, Speaker. I rise to indicate I'm the lead speaker for the opposition. The opposition supports the bill. There's a government amendment. There's a couple of opposition amendments that have already been aired in the other place. I'll just address the bill briefly. I'm not sure what bill the previous speaker was addressing, but clearly wasn't this one. In terms of remarks addressed to events in the private sector and so on, this is a bill that is and described by the government as meeting of an election commitment that the member for Gibson might have paid some, I think have had more to offer had the contribution of the member for Gibson actually been addressed to the subject matter of the bill, because it's very specifically about addressing the capacity of SAIT under the State Act to apply penalties to public sector employers. It's got nothing whatever to do with the private sector. And indeed, I might say even more sort of strikingly in the present circumstances, the government's chosen to progress this legislation at this time, not so terribly long after we've seen the trials and tribulations, literally the trial of the Attorney General's Department in relation to the battle that the United Firefighters Union of South Australia Incorporated was put to bringing to the SAIT just in recent months. So it's clearly it's a current issue, the capacity of public sector employers to fail in their duty to make good on their obligations to their employees. So far so good, but what the member for Gibson's got in mind talking about sort of private sector and you know, the role of unions in that respect is somewhat mystifying. It might also be just observed that part of the contest in this whole space, we've seen it sort of writ large in the Commonwealth space, the recent imposition of a $50 million penalty against Qantas, entirely different circumstances, but in that broader universe. The really rather controversial point about where does the penalty get paid? Where is that directed to? And you know, on this side of the house, we've made it clear in the other place, and we make clear again here, that we actually don't think that the occasion for the implementation of a penalty is a time when the union needs inevitably to get a great big payday, the result of the union being the party to the proceedings. And that's very much front and centre in the amendment that my colleague, our Shadow Minister for Industrial Relations, first brought to the House, first brought to the Parliament in the other place not so very long ago, because if the government and the member for Gibson, who has got some experience, greater experience than I do, in the world of unions and how they go about endeavouring to represent their members, has a clear-sighted view of this, then it'll be to think about, well, what are the appropriate arrangements in terms of the application of those penalty amounts to the members of the unions, to the employees who are wronged by employer conduct particularly in contravention of what will be the new section 104(1). And so we say employees should very much be the focus of those penalties that are applied to wrongdoing employers in the circumstances. In this case, public sector employers, and we don't have to look too far into the hypotheticals or the theorising, just to go back a short while and look at what the Attorney General's Department was required to make good on vis-a-vis the firefighters, to see that public sector in this state is much more than theoretically involved in the contraventions of workers' rights that's been found by the SAT, as I say, just in recent months. I refer to the contribution and it's the usual thoroughgoing and thoughtful contribution of the Law Society in this respect, and in particular 2 points. The first being that there's some curiosity about the maximum amount, the $25,000 that's provided for as the maximum amount, not being parity with the equivalent Commonwealth amount. That remains somewhat of a mystery, and I'd invite the Minister at the committee stage or in the course of the second reading to put anything that might be appropriately put on the record in that regard on the record. And the second one is the reference by the Law Society to this, I say, somewhat curious amping up of the costs provision, in that we're dealing with a jurisdiction that, regardless of what I think the attorney might have observed in the other place, a jurisdiction where costs are not routinely ordered, and this provision's then going, further down the line to make it really clear that you're not going to get costs ordered unless the court's satisfied that there's a frivolous or vexatious action that's been brought, or particularly in the case of an employer, one might expect there's been an unreasonableness. So if you put it this way, not too often costs being ordered, and this sort of open door for the payment of the new $25,000 payment to be made directly to the union. Now, it might be put as virtuous that payment can sort of somehow substitute for the efforts that the unions made in bringing the action. But if that were the case, if that were the rationale, then why not deal with it directly on the cost side? That doesn't appear to be the intent of the government. And so it seems to make really clear that to the extent that there is a contravention of what the new section 104(1), that's clearly affecting the rights of employees, should it not be the case that and it's relatively modest in the scheme of things, indeed significantly more modest than the Commonwealth equivalent, why shouldn't that amount be paid to the affected employee rather than to the union? And before I get kind of accused of going after the unions or unfairly getting stuck into them, that's not the intent, far from it. If unions are there doing their appropriate work, and I think unions would rock up and say that's our function, we'll come and bring actions on behalf of affected employees, sometimes a whole bunch of them, as as the United Firefighters Union, led by Max Adlam, did so ably just recently. Of course, that's what the union will do. It's a service that they'll provide for their members. But if not via a costs order for the action that's specifically taken, why shouldn't the results, as in any ordinary civil proceeding, of that action flow to the wronged employees, just like they would where a representative makes an effective argument in a civil action, the results of which there's penalties, the results of which there's an award made in the interest of the party. So that I grant is something that's still available to the tribunal. No reason not to make it expressly clear, particularly in circumstances where this debate is characterised by, highlighting the virtue of virtue of unions and the work that they do, standing up for the interests of their member employees. So a bit of work for the committee to do in a moment, Mr. Speaker. I'll take the chance in the committee to just ask the Minister to explain the government amendment in that remains unaddressed. I just refer to it in the second reading for the moment for that reason, and also refer to those couple of filed amendments that will be traversed in the course of committee on our side.